Alright, by the looks of it, we're going to be in for 2 months of serious vlogging. Viva Frei, Montreal litigator turned YouTuber, and where do we even start in these tumultuous times? The US elections were on November 3rd, 2020, and it doesn't look like they're going to be over anytime soon. As of today, November 5th, 2020, it's about 3:15 in the afternoon, and I've got to pick up my kids at school in an hour. The race is still too close to call, although Joe Biden is much closer to that very famous 270 than is Donald Trump. 270 being that magical number of electoral college votes that is required in order to be declared by the media as the next president of the United States of America. And although Joe Biden is closer, there are still a handful of swing states that are too close to call, and even if they get called in favor of one person over the other, there are going to be pending lawsuits for the next month at the very least. For those of you who might feel a little lost in this process, and understandably so, last night at the time of shooting this vlog, I did a live stream with Robert Barnes where we broke down what is going on, where things stand as of last night, what we should expect in the next month, and I hope people found it a little comforting. The purpose of today's vlog is to go through only 2 recent developments, the lawsuit that was filed in Michigan, and to go over the court order that was issued in the Pennsylvania lawsuit. They are both fascinating, but the news is moving actually so fast that I think there might have actually been a decision in the Michigan lawsuit, but let's first start with the court order coming out of Pennsylvania. In the Commonwealth Court of Pennsylvania, in re canvassing observation, appeal of Donald J. Trump for President, Inc. And now, November 5, 2020, upon review of arguments contained in briefs submitted by Donald J. Trump for President, Inc., appellant, the Philadelphia County Board of Elections, and the Pennsylvania Democratic Party, it is hereby ordered that the November 4, 2020 order of the Court of Common Pleas of Philadelphia County Trial Court denying appellant's oral motion to allow closer observation of the canvassing of ballots is reversed. The matter is remanded to the trial court to enter an order no later than 10:30 a.m. today, November 5, 2020, effective immediately, requiring that all candidates, watchers, or candidate representatives be permitted to be present for the canvassing process pursuant to 25 PS Section 2650 and or 25 PS Section 3146.8, and be permitted to observe all aspects of the canvassing process within 6 feet while adhering to all COVID-19 protocols, including wearing masks and maintaining social distancing. Opinion to follow. S. Christine Fitzano Cannon. Now, for those of you who might be asking the question, Judge Cannon was an elected judge, not an appointed judge, so that might quell any concerns of partisan bias that you might have. If she has partisan bias, we don't know what it is based on who appointed her, because she was elected. Moving on, as we can see from this order, it seems that the underlying proceedings, and I have not yet had the benefit of reading the underlying proceedings, is that it was a lawsuit taken by President Trump's campaign for president requesting access to supervise the ballot canvassing process. It seems that observers for the campaign were not being given proper access or adequate access to the canvassing process, and they had to petition the court to get closer access to the canvassing process, and the original judge said, no, we are not granting you closer observation of the canvassing process. The most important takeaway that we have from this order is that the campaign was in fact not being provided access within 6 feet of the canvassing process, which makes it very difficult to observe for anomalies, so to speak. The original judge denied the campaign's request to get closer observation, and the Court of Appeal said, no, you can get within 6 feet to the extent that you respect the COVID-19 social distancing measures, etc. And regardless of your political persuasions, the election process is supposed to be transparent, but it can't be very transparent when people aren't allowed to see it. And it seems from certain reports in the news that notwithstanding this court order, the representatives of the Donald J. Trump campaign for president were still denied access to the canvassing process. So that is the Pennsylvania order. The underlying issue is going to be whether or not the process for supervising the counting of ballots was properly followed, whether or not the process itself is legitimate, and if it is tainted with illegitimacy, what are going to be the consequences? To be discussed in the next live stream with Robert Barnes. Now let's move into the Michigan lawsuit, because I do have a copy of that actual lawsuit. State of Michigan in the Court of Claims, Donald J. Trump for President, Inc. and Eric Ostergren, plaintiffs versus Jocelyn Benson in her official capacity as Secretary of State. defendants. Verified complaint for immediate declaratory and injunctive relief. This is something we've talked about in previous vlogs. A complaint, a petition, a motion for declaratory relief means that you are petitioning the court to declare something as a state of law or fact. Injunctive relief means you are petitioning the court to order the opposing party to either do or to not do something, and when it comes to injunctive relief, you have your provisional injunctions, interlocutory injunctions, and permanent injunctions. Provisional injunctions being the most urgent type of injunctions, which typically carry you to the interlocutory injunction. The interlocutory injunction typically carries you till the final judgment, which is itself the permanent injunction. And you know what? Let's skip to the last page of the lawsuit just to see what orders they are in fact seeking in this lawsuit. Prayer for relief. These Michigan citizens and voters ask this court to A. Order, quote, a speedy hearing, end quote, of this action and, quote, advance it on the calendar, end quote, as provided by MCR 2.605D. B. Mandate that Secretary Benson order all counting and processing of absentee votes cease immediately until an election inspector from each party is present at each absent voter counting board and until video is made available to challengers of each ballot box. C. Mandate that Secretary Benson order the immediate segregation of all ballots that are not being inspected and monitored as aforesaid and as is required under law. D. Award these Michigan citizens the cost, expenses, and expert witness fees they incurred in this action as allowed by law. Dated November 4, 2020. First thing to notice here is that we have been seeing reports on the news of Donald J. Trump allegedly having said, cease counting the votes in Michigan, and we have been seeing reports to that effect because Donald J. Trump actually said, cease counting the votes in Michigan. But as we can clearly see here, the intent or the actual meaning of that statement is not to stop counting votes, period. It is to stop counting them until an election inspector from each party is present at each absent voter counting board and until video is made available to challengers of each ballot box. Probably a nuance Donald Trump ought to have included in his statement, stop counting the votes in Michigan, but for all of his qualities, nuance is not necessarily one of them. Now, back to the beginning of the lawsuit so we can understand what exactly is going on in that lawsuit. Donald J. Trump for President, Inc. of the United States of America and is a candidate for re-election in the 2020 general election. Donald J. Trump for President, Inc. is the campaign committee for President Trump and Vice President Pence. Eric Ostergren is a registered voter of Roscommon County, Michigan, and credentialed and trained as an election, quote, challenger. Eric Ostergren was excluded from the counting board during the absent voter ballot review process. And just in case you did not know what a challenger was and could not piece it together in the context, a challenger is someone who is appointed by a campaign to observe the conduct of the election process itself. Jocelyn Benson is Michigan's Secretary of State and is the, quote, chief elections officer and, quote, responsible for overseeing the conduct of Michigan elections. Secretary Benson is responsible for assuring Michigan's local election officials conduct elections in a fair, just, and lawful manner. Jurisdiction and standing, the Court of Claims has, quote, exclusive jurisdiction to, quote, hear and determine any claim or demand, statutory or constitutional, end quote, or any demand for, quote, equitable or declaratory relief, or any demand for an extraordinary writ against the state or any of its departments or officers, notwithstanding another law that confers jurisdiction of the cast in the circuit court, end quote. Donald J. Trump has a special and substantial interest in assuring that Michigan processes the ballots of Michigan citizens' case according to Michigan law so that every lawful Michigan voter's ballot is fairly and equally processed and counted. Eric Ostergren has a special and substantial interest under Michigan law as a credentialed election challenger to observe the processing of absent voter ballots. We then get into the background overview of the law, overview of the facts. There's nothing particularly complex in this situation. It's just that the ramifications of the situation are incredible. A general election is being held in the state of Michigan on November 3, 2020. MCL, which stands for Michigan Compiled Laws 168.765A regarding absent voter counting boards where absentee votes are processed and counted, states in relevant part as follows. At all times, at least one election inspector from each major political party must be present at the absent voter counting place, and the policies and procedure adopted by the Secretary of State regarding the counting of absent voter ballots must be followed. Michigan absent voter counting boards are not complying with this statute. These boards are being conducted without inspectors from each party being present. The lawsuit then goes on to explain how each party can designate a challenger who can oversee what's going on at each counting board. The lawsuit then goes on to describe the responsibilities of the challengers, the most notable of which are the following. An election challenger shall be provided a space within a polling place where they can observe the election procedure and each person applying to vote. An election challenger must be allowed opportunity to inspect poll books as ballots are issued to electors and witness the electors' names being entered into the poll book. An election challenger must be allowed to observe the manner in which the duties of the election inspectors are being performed.
duty.
An election challenger may remain present during the canvass of votes and until the statement of returns is duly signed and made. An election challenger may examine each ballot as it is being counted. An election challenger may keep records of votes cast and other election procedures as the challenger desires. And most importantly, an election challenger may observe the recording of absent voter ballots on voting machines. And then we get into the material allegations of fact. Local election jurisdictions locate ballot drop-off boxes without opportunity for challengers to observe the process, and as such, Secretary Benson violates her constitutional and statutory authority and damages the integrity of Michigan elections. Michigan law requires that ballot containers be monitored by video surveillance. Secretary Benson is violating the Michigan Constitution and Michigan election law by allowing absent voter ballots to be processed and counted without allowing challengers to observe the video of the ballot boxes into which these ballots are placed. Plaintiffs asks Secretary Benson to segregate ballots cast in these remote and unattended ballot drop boxes and, before the ballots are processed, removed from their verifying envelopes and counted, allow designated challengers to view the video of the remote ballot box. Secretary Benson's actions and her failure to act have undermined the constitutional right of all Michigan voters, including the voters bringing this action, to participate in fair and lawful elections. These Michigan citizens' constitutional rights are being violated by Secretary Benson's failure to prevent unlawful ballots to be processed and her failure to ensure that statutorily authorized challengers have a right to do their job. Then we get into the 3 counts under the lawsuit, the first of which is violation of the Equal Protections Clause under the Michigan Constitution, and bear in mind that every state has a constitution that is basically similar to the Constitution of the United States of America. And because it is not a true election lawsuit unless you cite Bush v. Gore, we are going to cite Bush v. Gore, obviously. Count 1. Secretary Benson violated the Equal Protections Clause of Michigan's Constitution. Michigan's Constitution declares that, quote, no person shall be denied the equal protection of the laws, end quote. This clause is coextensive with the United States Constitution's Equal Protection Clause. Harville versus State Plumbing and Heating. See also
Bush v. Gore.
Quote, having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another, end quote. Plaintiffs seek declaratory and injunctive relief requiring Secretary Benson to direct that election authorities comply with Michigan law mandating election inspectors from each party and allowing challengers access to video of ballot boxes before counting of relevant votes takes place. Count 2. Secretary Benson and Oakland County violated Michigan voters' rights under the Michigan Constitution's, quote, purity of elections clause. The Michigan Constitution's, quote, purity of elections clause states, quote, the legislature shall enact laws to regulate the time, place, and manner of all nominations and elections, to preserve the purity of elections, to preserve the secrecy of the ballot, to guard against abuses of the elective franchise, and to provide for a system of voter registration and absentee voting. Quote, the phrase purity of elections does not have a single precise meaning, but it unmistakably requires fairness and even-handedness in the election laws of the state. Plaintiff seeks declaratory and injunctive relief requiring Secretary Benson to direct that election authorities comply with Michigan law mandating election inspectors from each party and allowing challengers access to video and ballot boxes before counting of relevant votes takes place. And finally, count 3, the Secretary of State is violating of MCL 168.765A. As we have seen, that provision of law pertains to the counting of absentee ballots, and when they are counting absentee ballots, there has to be at least one inspector from both parties, or there has to be the opportunity for there to be an inspector from both parties, and apparently the absentee ballots are being counted in the absence of an inspector from both parties. Michigan absent voter counting boards under the authority of Secretary Benson are not complying with this statute. These boards are being conducted without inspectors from each party being present. And the lawsuit has apparently already been dismissed because it is moot because the counting has already been done. A Michigan judge on Thursday dismissed a challenge from the Trump campaign to ballot counting in Michigan, saying local officials have already finished counting ballots cast in the November 3 election, and there is no legal basis or evidence to grant what the campaign requested. The Trump campaign filed the lawsuit late Wednesday in an apparent last-ditch effort to stop Democrat Joe Biden from overtaking Republican President Donald Trump in the Michigan vote tally as clerks tallied absentee ballots in Detroit and other major cities that predominantly went to Biden. Trump has filed similar lawsuits in other closely contested battleground states. Michigan Court of Claims Judge Cynthia Stevens said the ballot counting in Michigan, which shows Democrat Joe Biden receiving about 150,000 more votes than Republican Donald Trump, was completed Thursday morning. That made the access request moot, but Stevens said Benson already issued a directive for meaningful access for poll watchers at local ballot counting places. That directive arose from a separate recent lawsuit related to ensuring proper access during the coronavirus pandemic with the associated social distancing requirements, she said. As for the videotapes, Stevens said there is no legal basis for Benson to provide or be expected to provide access to surveillance video of ballot drop boxes installed by local officials. And there is already an entry in Wikipedia as relates to this judgment, which reads as follows. On November 5, 2020, Judge Stevens dismissed a lawsuit filed by the Trump campaign over the handling of absentee ballots in the 2020 presidential election. The campaign alleged that the Michigan Secretary of State, Jocelyn Benson, had undermined, quote, the constitutional right of all Michigan voters to participate in fair and lawful elections, end quote. Judge Stevens not only ruled that the case was based on hearsay and should be dismissed, but also stated that Benson was the wrong person for the Trump campaign to sue, as she does not control local ballot counting. In any event, the damage had already been done, and it's very difficult to get this toothpaste back into the toothpaste squeezy thing. I forget what that's called now. Anyhow, that is one lawsuit of what I suspect is going to be many lawsuits in the wake of this November 3rd, 2020 presidential election, and I will be doing vlogs on all of those lawsuits of interest and discussing them with Barnes as they come up. One thing is for certain, regardless of the outcome of the election, holy cows, the school bus, remind me, I gotta go get my kids. Regardless of the outcome of this election, people are going to have lost faith in the process, and with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. Robert Barnes and I have a community page on Locals. It is called vivabarneslaw.locals.com. Be sure to check us out there if you are so inclined. Get some merch if you want to get some merch, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well during these excessively stressful times, and now you know your vlog. Peace out.